I want to just quickly review that, as you recall, in the last meeting, for those of you who were here, that I had explained why it was that many people believe that we are going to be confronted in the very near future, between 2020 and 2040, with a major secular crisis in the United States, very similar to those that had occurred in the 20th century, in the 19th century, in the 18th century, in the 17th century, that there's a pattern that recurs in American history, and that the primary reason for all of those previous crises is the same that's projected for this 21st century, and that is that the civic generation of the previous century had gone too far in confronting and attempting to redress the major secular crisis of their century, had gone too far in compromising the fundamental idealistic principles of our country, and additionally had remained inflexible in their attachment to the compromises that they had made in the face of a major upheaval on the part of the idealistic generation of their century, attempting to critique those amendments that had been made in our structures and institutions to try to get them to more fully comply with the ideals of our country. And for similar reasons, I pointed out that we have every reason to anticipate a similar major secular crisis in the not too distant future that will very likely disrupt not only your particular lifestyle, but your life plan. We discussed that, and I pointed out that if in fact William Strauss and Neil Howe, two major scholars, one from Harvard and one from Yale, that were doing their fellowships at Notre Dame when they prepared a major sociological study entitled Generations, A History of America's Future. If they are correct in their analysis of the previous centuries in American history, that the source of the overcoming of the upcoming crisis here in the 21st century will be a major alliance that is established between the idealist generation of the 21st century, which is the classic baby boom generation, of which I am a member, and who were born basically between February of 1943 and November 22nd of 1963. And that alliance will be established with you in your generation, the civic generation of the 21st century, born between 1979 and 2000. I had closed our first meeting with the account of Crane Brinton's final lecture at Harvard University, the man who had been the chair of the Department of Intellectual History at Harvard University, that he had taught there for some 45 years, from 1923 to 1968. And as you'll recall, when he was asked to, in his final lecture on December 19th of 1967, was asked to identify the single most important idea that he had encountered in all 45 years of his being an expert in the field of intellectual history for our human family. He had stated that he had no doubt at all about what that single most important idea was, and that was that our human family is standing right now on the very brink of a major biological step in evolution and that is going to distinguish the next incarnation of our species. Is going to be different from Homo sapien as Homo sapien is different than Homo erectus. And that he thought that the particular faculty that was going to evolve biologically in our human family, that was going to distinguish this new manifestation of our human species, was going to be the development of a faculty very much like seeing or hearing or touch or taste or smell. It was going to be a new faculty by means of which each individual human being could directly and experientially experience the unitive phenomenon that bonds together every single ultimately irreducible integer of matter in the entire physical cosmos into one unified harmonic whole. And that by means of this experience, each individual human being was able to directly experientially discern what conduct on the part of human beings, both individual and collective, is either harmonious with or disharmonious to the natural order of the universe. And that this particular observation that he made is, I intended to argue in this second meeting, is in fact the essential underlying engine of the progressive movement in the human family. And I was intending to explain, in light of the fact that the 8 cases that we're going to be discussing in the course of the next 10 weeks were a confrontation between the progressive forces in our country and another element, which is a reactionary worldview. I was going to spend some time today explaining to you some of the more recent advocates of this particular worldview, and suggest that you might be interested, while not assigned, you might be interested in a sense, getting up to speed with what it is that the baby boom generation during our foray in the confrontation with these reactionaries had come to know about as sort of the touchstones of the more modern articulation of this worldview. And I was going to point out to you that one of them was Pierre Teilhard de Chardin, who is a Jesuit priest, Catholic Jesuit priest, who was a paleontologist, PhD paleontologist, who actually discovered Peking man. And he wrote a major piece called The Phenomenon of Man in the early 1920s, in which he discussed this very idea, that there was this faculty evolving teleologically and progressively in the human family that was going to enable us to basically have this type of experience. He went so far as to suggest that the reason that Jesus Christ is as well known as he is because he was one of those who was a mutation, a biological mutation that actually had this faculty fully evolved prior to the time that it would normally come into fruition in a very major way, like many biological mutations do occur out of time, and therefore they don't survive because they are so in disharmony with the disharmonious culture or environment in which they find themselves that they are in fact destroyed. And because of this, his writings were silenced by the Committee on Orthodoxy of the Catholic Church, headed up at that time by Cardinal Ratzinger, who is now Pope Benedict XVI. He was one of the reactionary elements, and still is, in the Catholic Church, having served in the Secretariat of State for Pope Pius XII and helped to negotiate the Concordat with Nazi Germany that caused the Catholic Church to stand idle in the face of the Holocaust. And so Teilhard de Chardin was a person who set himself against that reactionary element in the Catholic Church and espoused an entire supportive superstructure, biological superstructure for the progressive movement. Another major person who I was going to be telling you about is Evelyn Underhill, a major champion of the progressive worldview, that she was actually a major instructor at King's College and Oxford, which was a very rare event for a woman back in 1911. And she published a major work called Mysticism, and went on to write other books, a biography of a number of major mystics, and that is a book that I would recommend to you, not to have to read for this course, but it's one that you want to have on your bookshelf to be able to take a look at and review, because it's an extraordinarily perfect discussion of the issue of this faculty that she's talking about. And she discusses it from the point of view of an intellectual perspective, a psychological perspective, a philosophical perspective, and it's an extraordinary piece. In fact, it was the most widely read piece of literature in Western civilization about this particular faculty up until 1945, when Aldous Huxley wrote his fairly famous book called The Perennial Philosophy and his Doors of Perception. A third person that I was going to be telling you about is a man by the name of Henry Bergson. Henri Bergson is a fabulous read for you to take a look at. He wrote a number of major books called Creative Evolution, An Introduction to Metaphysics, and a very important work in 1932 called Two Sources of Morality and Religion. And in this, he sets up the juxtaposition between these two worldviews that I was going to be discussing today in some detail. And I was hoping to track these ideas, the reactionary worldview and the progressive worldview, up through history for you in preparation for the discussion of the 8 cases that we're going to be discussing in detail in this course, explaining the whole historical evolution of this progressive idea about the role that this intuitive experience plays in undergirding the morality and the progressive worldview of the progressive movement. Now, I was doing this so as to set up for us this moral combat that you are going to see taking place in these 8 cases throughout the course of the next 10 weeks. And I was going to, however, I wanted to caveat at the very beginning of our course together and our meetings together and discussions that we're going to be having about this, that the progressive worldview and the reactionary worldview are not the only 2 worldviews, that they in fact fall in a spectrum of worldviews. And of course, you know right away that in addition to the progressives and the reactionaries, there are the very well-known liberals and conservatives. Except that it's important to understand that the reactionaries are much farther onto the right side of the spectrum than are simple conservatives. And in fact, progressives are much farther to the left on the political spectrum than are simple liberals. And of course, we're all familiar now with the moderates, the new, more moderate Democratic Party, for example, of the Democratic Leadership Council that was founded by Richard Gebhardt, a Democrat from Missouri back in 1980 after the election of Ronald Reagan. And a number of people in the Democratic Party thought that, well, the only way to beat them is to join them and to become much more conservative or more centrist, as they said. And it gave us people like Bill Clinton and Al Gore and more recently, unfortunately, Barack Obama, who, much to the chagrin of a substantial number of people who voted for Obama, have come to discover that he was surprisingly more moderate and conservative than they thought he was going to be. That he has established compromises with the major banks, with the insurance industry. He's taken positions with regard to the environment and global warming that are a very major part of the problem. And so that I was going to have a discussion with you today about this spectrum, to lay out for you the different worldviews that are companions to the progressive worldview and the reactionary worldview, so that you would understand that even though it's our thesis in this course that the driving engine of the American progress in the last 150 years has been what is essentially a dialectical struggle going on between adherence to the progressive worldview and adherence to the reactionary worldview. But because it's Passover and Holy Thursday night, and a number of people who want to participate in that deeper conversation may not be here tonight, and because there are a number of new students here who were not here for the initial conversation about some of the active, concrete things that were going on back in 1968 in setting the stage for this moral combat that we're going to be discussing in this course. It has been suggested to me by our TAs that rather than start this type of a philosophical, metaphysical discussion at this initial stage, we should wait until everyone is signed up and everyone's here and we know who all is going to be in the class, so that we can make sure everybody participates in that conversation, because it is so foundational for understanding what it is that we're doing. And so they have suggested that rather than that, what I should do tonight is I should talk with you about a number of the other cases that I participated in and that I've litigated during the same period of the 8 cases that we're going to be focusing our attention on, so that those who are new to the class can get some kind of a flavor of what the nature of the kind of cases are that we're going to be talking about, so you can decide whether or not you find them adequately interesting to actually take the steps of potentially dropping one of the other courses and coming and taking this one, or if you haven't made a final decision on your courses, to take this course. And so that I've been asked to do this. So I'm going to spend this time together telling you about a few of the other cases in the same way that we'll be talking about the other major 8 cases that we're going to be dealing with. You can see in the syllabus, those of you who are new, what the 8 cases are going to be. But what I want to do today is I want to talk about these cases sort of in the order in which they happened. As I was discussing with the 30 of you who were already registered when you were here on Tuesday night, that when I graduated from Harvard Law School in 1970, having served since 1968 as the co-editor of the Harvard Civil Rights Law Review, I had started a number of litigations while I was still in law school, prior to being in the bar. The New York State Bar Association had a fairly intense conversation with me about that at the admission discussion. But we had started some of these cases. One of them, which we will talk about in the course, was the case that established the right of journalists to protect their confidential news sources. And because I had started that case when I was still in law school, and the particular NBC television journalist who I was representing, John Pappas of NBC News, refused to allow the major law firm that represented NBC to represent him in front of the United States Supreme Court, and insisted that I do that, because I was the one who identified this right, which nobody in the NBC law firm believed was true. And so he did not want them arguing in front of the Supreme Court on behalf of this right, in which they didn't even believe. And so I was recruited by the #1 law firm in the country, Cahill Gordon, Sonnet, Reindel, and Ohl on Wall Street, who represent NBC News, their national litigation. They came to recruit me at Harvard Law School in May of 1970. I remember that Jack Armstrong came to interview me, one of the partners, and when I came into the room for the interview, I saw this great sigh of relief go over him and the other fellow who was with him, because even though my name was Daniel Sheehan, they had noticed on my resume that I was a member of the Black Harvard Law School Society. And they were living in dread that even though I had an Irish name, that I might have been black. And they wouldn't have known what to do about it. Because the law firm, the 178 trial lawyers that are there, that are partners, are half Jewish and half Irish. But no blacks, no women. But so they were afraid that I was not going to fit in, and they wouldn't be able to recruit me, and therefore they wouldn't get to do the case. And so when they found out that I was there, they explained to me this peculiar thing about the law firm, the Cahill firm, as they refer to it, is that they said that the reason that they had half Jewish partners and half Irish partners is because the Jewish lawyers were all the editors of the major law reviews in most of the major law schools, and were so smart and so intelligent and so hardworking that they could figure out the legal argument to make on behalf of any position. And the Irishman would break a chair on you and bite you in the ass and hold on until you died. And so that they always tried to partner up one of the new Jewish associates with the new Irish associates. And so I came into the firm in June of 1970 after having graduated from Harvard in May. And right off the bat, I had a special deal because I realized, like a good young lawyer, the power position that I was in. And so I said that, in fact, I wouldn't agree to go to work for the #1 law firm in the entire country unless they made some special concessions. And so they agreed to allow me to spend half of my billable time on doing public interest cases, as long as I used the other half of my billable time doing cases for their clients. Now, this wasn't too difficult for me because one of the clients that they had was NBC News, and so I could do a lot of the First Amendment work for NBC. So that's what I began to do. But as soon as I arrived in June, I contacted the law commune in New York City, a fairly well-known group of about a dozen young, very progressive lawyers, and contacted them and let them know that I was there. They had heard about me because I had done a couple major cases while I was still the co-editor of the Law Review for the Black Panthers up in Boston. That I won't touch on all of those cases right now because I want to focus on a few of them. But I had done a case which got a major federal injunction against the Boston Police Department because the Boston Police Department, every time there was a robbery and the suspect was a young black male, they would go around and arrest all of the Black Panthers in the city that were on the street corner distributing Black Panther newspapers. And they would arrest them all as potential suspects. And then they would bring them to the lineups, and they'd place them in lineups all day long. And then at the end of the day, if nobody had accidentally and mistakenly identified them for being a culprit in some crime, then they would let them go. But the Boston Police Department would always lose all of their newspapers before they would let them go. And so a young lawyer by the name of John Flynn, a brand new lawyer in Boston, was contacted by them and asked to help them. And so he responded to the letter that we had sent out, soliciting offering our services. And so I ended up doing the major federal injunction that got a federal injunction commanding the Boston Police Department to stop doing this. And I had gone on to represent the NBC television cameraman, John Pappas, in a major case that arose out of riots that the Black Panthers had been targeted by the grand jury to charge them with starting these riots. So I had some reputation of having worked with the Panthers, so I contacted the law firm, the law commune, because they were representing the Black Panthers in the Panther 21, which is one of the cases we're going to touch on today. But when I contacted them right in June of 1970, after having arrived, they said, oh, look, there's a case that's getting ready to happen. We'd like to have you help us with this. And this is going to be the first case that we're going to talk about tonight. This is the case of Cortright versus Reeser. This is the case of the first U.S. Army regimental band at Fort Hamilton, New York. It turns out that in June of 1970, there were 55 members in this band based at Fort Hamilton outside of New York. And the drum major for the first U.S. Army band was a young man by the name of David Cortright. David Cortright had graduated from Notre Dame in 1969, and he was going on to Juilliard School of Music, and he got drafted at that time. And now you remember, in 1969, 1968 and 69 is the high water mark of the Vietnam War, losing 535 Americans a month getting killed, and some 2,500 a month getting seriously wounded, and not even accounting for all the thousands of innocent people in Vietnam that were being killed by this. And so when he was drafted in 1969, he refused to go and told them so, and said, look, I've got this full scholarship to Juilliard to do graduate studies in music, and I'm not going. So they sent him a letter and said, look, we understand what your position is. Tell you what you do. If you will agree to volunteer for the United States Army, we will guarantee you that you will go into the U.S. Army band, the first regimental band, the primo band for the United States Army. And you only have to serve for 1 year, and that will exhaust your requirements. And so Cortright said, well, okay, despite the fact that I think this is an unlawful war, as long as I'm guaranteed to go into the band, I'll do this. So they did. They withdrew the draft notice. David goes in and signs up, and they assigned him to Fort Hamilton. Within a month, he had become the drum major for the first U.S. Army regimental band, which meant that he was the domo. He was the guy that commanded them. He's the guy that gave them all their music lessons. He's the guy that was kind of in charge. And what he did is he set about organizing them because they had special privileges, the band. They did not have to appear in the morning for reveille. They didn't have to get haircuts like all the rest of the Army guys had to do. They got to live off the base. They didn't have to do KP. They didn't have to police the grounds. They didn't have to do any of that stuff because it was a very privileged group. So what they did is David Cortright set up a coffee house right next door to Fort Hamilton and began to organize against the war and began to print up pamphlets against the war and began to invite military guys to come over, and they would do speeches and stuff against the war, etc. And the commander at the base, General Higgins, began to get really pissed about this. And the Spec 4 that was their administrative director, this guy Patrick Flores, went to Cortright and said, you guys had better stop doing this. And Cortright said, screw you. We have a right to do this. This is our First Amendment right. We can do whatever we want to do. We're off the base. We're not in uniform. We can do whatever we want. And so Flores said, well, I'm not sure that's true. And so Cortright, in order to test it, organized the band and had 38 members of the 55-member band sign a full-page ad in the New York Times with their name, rank, and serial number opposing the war in Vietnam, and published it in the New York Times. At which point, they came back, it was a Sunday Times, and so they came back a Monday morning, they came to reveille, and they were all there, and Flores comes out and he starts ranting and screaming at them about how absurd this thing was that they had done, that they put their name, rank, and serial number, they published it in the New York Times, millions of people saw this around the country, and Higgins was pissed. And he said that you're going to have to stand here at attention, and I'm going to go talk to General Higgins, and I'll be right back. So he takes off and goes to see General Higgins. And so the guys break ranks and they go and get their tape recorders. And so they bring their tape recorders back, and when Flores comes back, they've all got their tape recorders on. They're all standing there, and he says, okay, you're in for it now. General Higgins has said that, look, you guys have all these privileges. And he lists them all out. And if you guys continue doing this kind of stuff, he's going to take these privileges away from you. and he's going to not let you have any music lessons. He's going to make you live on the base, get your hair cut, clean up the place, do KP duty all the time, clean up the offices and dump all the garbage and all that stuff. He said, if you do something like this again. And so they Cortright called the law commune and said, help, Higgins is threatening us, going to interfere with our First Amendment rights. So when I contacted the law commune in June of 1970, having announced my arrival in New York and my availability to try to help them, that I have half of my time, that I get to do this kind of stuff, they bring me over, sit down, interrogate me to see if I'm adequately radical, and they decide that they're going to assign this case to me to work with Fred Cohen. And Freddie Cohen and Marty Stoller were the two of the lawyers there. And so we began to talk with Cortright. And we explained to Cortright what his rights were and what he had a right to do and all of this stuff. And so what happened is we drafted up a federal injunction, seeking a declaratory judgment and a federal injunction prohibiting General Higgins and the command structure from doing anything to intimidate them, to stop them from exercising their First Amendment rights. And so the guys decided in order to challenge this, that what they were going to do, they got called in one time because somebody brought some of the flyers against the war from their coffee house, and they were found on the base. So somebody found these things and brought them to Flores, and Flores said, okay, you guys are in real trouble, you're bringing these things onto the base. And so we drafted up the motions and stuff, and they said, look, you try to do anything to us on this, and we're going to sue you for it, because you can't even prove that we're the ones that brought them here. Anybody could have brought these things here because it's a public coffee house. So they let him go. And then the 4th of July comes around in 1970. I've been at the firm for a month now. And the 4th of July, the 1st U.S. Army Regimental Band is asked to go and lead the parade, the 4th of July parade on Staten Island. And so the 55-member band goes to Staten Island, and they're marching down the street, and David Cortright's fiancée and 5 of the wives of the other people in the band are marching along next to them on the sidewalk with signs saying, "Nix on war. Does the fact that we've killed 10,000 people make us great? Kill poverty, not people." They were marching along next to them, and the veterans of foreign war that were in the parade see them doing this, and they go ballistic, and they attack the women, and they break their signs, and they punch them out on national television. Turns out that this is the great big regimental band, and the major networks were kind of videoing this as the kind of paradigmatic parade, and there they were. And so it goes out all across national television, all across the country. And so they come back on the Monday following the 4th of July holiday, and they come to assembly, and they bring their tape recorders with them, right? So they got the tape recorders, and Flores is ballistic, jumping up and down, saying, Higgins saw this all over the television, you guys stay here, I got to go up and see him. They go upstairs, he's in there 15 minutes, he comes back, that's it, he says, it's curtains for you guys. You're going to get your hair all cut, you have to move in on the base, you're going to do KP, you don't get any more music lessons, you guys are screwed for what you guys did here. Okay, so of course they contact us right away, and so I start amending the little proposal we've got, the little federal court order that we're going to get on these guys. And so, but then I say to them, I say, look, Cortright, you guys better be careful, because they're probably going to do more than that to you. So you better be alert. And it turns out that because our guys had been assigned to clean up all the offices, turns out that what they were doing is they went into General Higgins' office to clean up and empty the garbage pans and to empty out the burn bag where all of the classified information is, because at that time they didn't have computers and stuff. They would type out any letters that they wanted to do on one ribbon, on a typewriter ribbon, and then they would throw it away, take it off the typewriter and throw it away because it was a classified letter and they didn't want it sitting around, so they'd throw it in the burn bag. So what our guys did is they go into the burn bag, because they were responsible for taking it out and burning it. They open it up, and they take out the ribbons and hold them up to the light and start unrolling them, and they find the letter. that General Higgins has sent to General Seacraft, who is the commander of all placements in the United States Army. He's written a letter down to the Pentagon demanding that these guys be transferred because he wants them out of there. But it says in there, so he orders them to be assigned to frontline combat units in Vietnam, except for David Cortright. Don't send Cortright, he's got lawyers, it says in the letter. So they find the thing, and because they're in the office, they say, okay, now let's see. Here's General Higgins' letterhead stationery, which they take out of the drawer, and here's the typewriter on which it was typed. And so they sit down and they retype the letter, including everything, all the way. The guys reading it off a little ribbon to them, and they're typing it all out. And so they get a copy of it, and they send it to us, to our office, right? And so what we do then is we end up filing a motion in federal court in the Eastern District of New York in front of Jack Weinstein. Jack Weinstein is an LBJ appointee. He's appointed to the federal bench in 1967. He also is the constitutional law teacher at Columbia Law School. And so we bring the motion on to Jack Weinstein, and we demand an immediate deposition of General Higgins for the following day. Jack Weinstein signs it, and we serve it out at Fort Hamilton. Okay. Meanwhile, my law firm is going, what are you doing? We thought the kind of public interest cases you were going to be doing is like, as I said the other day, if some family buys some furniture, like a couch, and they pay all of their payments except for their last payment, and they miss the last payment, and some fly-by-night company comes and takes their couch back. I mean, that's what we thought you were going to be doing. That's like legal aid work. If you read the stuff on cause lawyering, that's that little nitty-picky stuff. And so I said, no, there's this case here. It's a very important First Amendment case. And so we bring it in front of Jack Weinstein. He signs the order immediately subpoenaing Higgins to come to the deposition the next morning at 10 o'clock in the federal courthouse in the room next door to where Jack Weinstein's chambers are, so that he'll be available in case he's needed. So we're all sitting there waiting. It gets to be 1 minute to 10, and the door opens, and in walks Major Starr, the chief judge advocate for the first U.S. band, or first U.S. Army. And he walks all by himself, without General Higgins. And he walks in, and Fred Cohen, who's this big 6'6" guy with a big gigantic fro and big handlebar mustache for the law commune, says to him, well, Major Starr, he said, it's now 10 o'clock. I'd like to go up on the record and note that General Higgins is not here. Can you tell us exactly what your explanation is for why he's not here? Major Starr says on the record, General Higgins is a general officer in the United States Army, and he does not have to appear except by his own consent. Freddie says, really? Really? Isn't that the code of military justice for court-martials and stuff? He said, yes, and it's our position that applies to federal civilian courts. Fred says, I think we better go see Judge Weinstein. He happens to be waiting for us in chambers, and so we're going to go over there. So we go over. Judge Weinstein gets up on the bench, and he sits there, and Fred gets up in front of us. So it's Fred Cohen and myself in front of the judge, and Fred says to the judge, Your Honor, he said, it's now 10:15, and the record shows that General Higgins hasn't appeared here, and I'd like to have Major Starr tell you what their position is. So Major Starr says, Your Honor, General Higgins is a general officer in the United States Army, and he does not have to appear except by his own consent. Big, long silence. Judge Weinstein stands up at the bench, and he goes like this over his glasses, and he goes, excuse me, Major Starr, he says, I must not have heard you correctly. He says, could you please speak up for the record? And Major Starr says, General Higgins is a general officer in the United States Army, and he does not have to appear but by consent? And Judge Weinstein says, Major Starr, I'm afraid that General Higgins doesn't understand the gravity of the situation. Why don't you do this? Why don't you give me his private phone number, and you guys wait here, and I'll go talk to him on the phone. He said, so he says, look, what's your position on this? He says, Mr. Sheehan, and Mr. Cohen, he says, and Fred stands up and he says, Your Honor, I'd like to make a motion to have General Higgins held in direct criminal contempt of court and sentenced to 6 months in federal prison at Leavenworth. Jack Weinstein says to Major Starr, well, Major Starr, you heard him. I don't think he agrees with the position, he says. So look, why don't you just give me that phone number and let me go talk to General Higgins. So he leaves the bench. He comes back in about 10 minutes. He gets back up on the bench and he says, well, he says, General Higgins has agreed to appear voluntarily at 2 o'clock. He'll come. He says, but only on the condition that only Mr. Cohen and Mr. Sheehan and Major Starr are the only people that will be allowed in the room during the deposition. What's your position on that? He says to Fred Cohen and myself. And Fred says, Your Honor, I'd like to renew my motion to have General Higgins held in direct criminal contempt of court and sentenced to 6 months in federal prison at Leavenworth. And so Judge Weinstein says, well, Major Starr, I don't think they agree to that condition. I think you'd better have the general here. So we all break, right? And we go back to the law commune. We start gathering every big blow-haired freak we could find to bring them to the deposition, right? So we get all the staff, we get everybody there, we go out on the street, we get homeless people, we bring them in to the deposition room, right? Okay, 2 o'clock shows, 2 o'clock, ding, ding, in walks General Higgins, lid under his arm like this, his hat like this, walking, big, huge spaghetti all over his uniform, and he comes in, you can see his head right through the top of his hair, one of these guys, and he looks and sees all these people, and he looks completely stunned like this. But he goes over and he sits down, and Fred Cohen comes over and he says, okay, we're going up on the record now. Let the record show that General Higgins is here. Could you give us your full name and address? So he gives us his name and address, and Fred comes over to where he's sitting down, and he pulls a chair over like this, Fred does, and he stands up from me and he goes, well, General, he says, can you tell me why you transferred David Cortright and all these other men to frontline combat units in Vietnam? And John Higgins says, those men were transferred in the normal course of administrative affairs of the United States Army. Fred says, really? He says, Mr. Sheehan, could you get that letter, please? So what I do is I walk over like this, and I open up the briefcase, snap it open, and I take out the letter like this. And walk it over like this, right in front of General Higgins so he can see it just like that. And there it is. Higgins looks at it, and he kind of turns the color of his uniform. Whoa, he goes, what's that? So we go over here, and so he says, Mr. Sheehan, I'd like to have you read the letter into the record. And he says, General Higgins, if there comes a point in time at which the reading of this letter refreshes your recollection as to what the actual answer to that question is, you just stop us any time. So I snap the letter like this so he can see it perfectly clearly, and I start to read from it. So I get about, into the first paragraph, and he says, okay, so look at. These men were disrupting a unit of the United States Army. He said, and every single unit of the United States Army has to remain combat ready at every moment. And these men were interfering with the combat readiness of this unit. And Fred Cohen looks at him and he says, the band? Yes, the band. He said, that may be their primary assignment, but every unit of the United States Army has to remain combat ready at all times. And it's my position that they were interfering with that. He said, Freddie says, I think we've got enough here. Why don't we go see Jack Weinstein? So we go back over to Weinstein. He's in the chambers. We read back the deposition to him, and he says, General, what you're going to have to do is we're going to have General Seacraft, that you wrote this letter to, appear here tomorrow morning at 10 o'clock, or I'm going to have to hold him in contempt of court. And I will entertain a motion to have him put in Leavenworth prison if he's not here. And by the way, have him bring the letter if he's got a copy of the letter. And so they issued the subpoena ducis tecum, and the next morning, in comes General Seacraft. He gets up on there. He's got the letter. First thing we do, we walk over to him and say, General, do you have the letter with you? Yes, I do, right here. Snatch, just like that. We said, great. We said, here's the letter. Here's the letter with the signature. And so Jack Weinstein goes ahead and enters a federal court order commanding that every single one of the men who have been sent to Vietnam be put on a first-class commercial airliner and flown back to the United States at the cost of Fort Hamilton, and that they bring them back. and that David Cortright, who had been transferred to Fort Bliss, Texas, into a unit that was overfilled with people already in the band, order him to come on back and bring him back, and that he ordered them to post in every one of the conspicuous places all throughout the base a letter of apology, a personal letter of apology from General Higgins for having violated the First Amendment rights of these men. Okay, well, that was the first case I did when I was there at the Cahill firm. Now, an important footnote, and it's important for the nature of the kind of conversations we're going to be having with regard to the other cases. The United States military appealed that decision after the men had already been brought back. Of course, they had to obey the emergency order, brought them back. They appealed it to the Second Circuit Court of Appeals, and Judge Friendly entered an order reversing it. Judge Friendly, remember now, Jack Weinstein having been appointed by Lyndon Johnson, a Democrat. Judge Friendly on the Second Circuit Court of Appeals having been appointed by Eisenhower, a Republican, in 1959, to take the place of a Democrat who had been appointed by Truman, but now there was a Republican there, and so Judge Friendly, with another member of a Republican judge appointed, enters an order setting this aside. And even though the men have already been brought back, and they didn't send them again. And then there was a dissent in the case by Justice Oaks. And so if you're interested, you could look these up and read this thing. The decision by Jack Weinstein at the district court level is at 325 Fed Sup. That's F period, S-U-P-P period, 797. But all you have to do is go to Google and put in Cortright, C-O-R-T-R-I-T-E, V. Reeser, R-E-S-O-R, Cortright versus Reeser, and you'll get it, and you'll get both this and the appeal. And so that it's an interesting exercise because you read through that and you say, look at how could two intelligent, well-educated judges have such a completely profoundly different view of what ought to be done with these. And so that's a good beginning in the case. Now, the next case that I got is that this one began a little bit before I was there. And this is the Panther bombing conspiracy case. Yes?
Hopefully you could correct me on this, but I was under the impression of when you join a military branch, you voluntarily give up certain rights that you have normally as a citizen.
Certain.
And such as you no longer have the right of your First Amendment.
Nope. Nope. You'll see when you review both courts agreed that wasn't true. Both courts agreed, both the district court and the Court of Appeals agreed that when you join the military, you don't give up all your First Amendment rights. So the real question became is, well, how much of your rights do you give up? What kind of authority does the Army have to restrict your rights, et cetera? And that's where that's the dynamic that went on in the conversation. But fortunately, there had been litigation already established asserting that First Amendment rights are not, in fact, waived because you don't join, you're drafted. Okay, and so the question arose as well, because he signed up and volunteered, did he have different rights than people who were drafted? You see, because I mean, if you're just walking along as an 18-year-old guy and they come and say, I'm going to put you in federal prison for 10 years if you don't come, do you voluntarily waive your First Amendment rights by the fact that you don't go to Canada? So those are the kind of questions that got addressed in this particular case. Very interesting discussion with these judges. Okay. Second case was, as I said, it started before I got there. And this was the Black Panther case. This is a very famous case called the Panther 21. This ranks right up there with the murder of George Jackson and the Fred Hampton, the assassination of Fred Hampton in Chicago. This is one of the big famous cases for the Panthers. And what happened when I arrived in June, and I had already contacted the law commune to be able to volunteer to help them, given the fact that I have half of my time that I can do this. And so I knew this Panther case was going on. And so I had assumed that I was going to end up working to help them on this case, which I did. Okay? And so what happened is in January of 1969, this is like a year and a half before I arrived in June of 1970, On January 17th of 1969, 3 high-level members of the Black Panther Party in New York were driving along the Hudson River Parkway in New York City. Yes?
You might explain a bit about what the Panthers were. I don't know.
Okay, well, the Black Panthers, it was called the Black Panther Defense Party. It was an organization of radical black males, mostly to start with, organized out of Oakland, California here. And they became more and more aggressive in their resistance, as they put it, to police brutality, violation of rights of black people, discrimination against black people. They began daycare centers. They began breakfast programs for young black kids. They had 2 basic arms. One was the public service activities that they engaged in the black community, and the other one was a very militant, strident, get-in-your-face defiance of police, whom they accused of being consistently racist and violating the constitutional rights of black people in ghetto areas, et cetera. And so the police developed a very strong antipathy toward the Black Panthers, which was mutually shared on the part of the Black Panthers. And Black Panthers used to publish their newspapers, like, for example, they'd have on the front page of the newspaper a police officer who was in fact a pig on the picture. And they would have police uniforms on and stuff like that. And the police started getting really upset because the Black Panthers used to constantly refer to them as pigs. And so the police, every time they get a chance to do anything to them, such as in Boston, they would go around and arrest them on any excuse they could come up with, usually not a constitutionally well-founded excuse. And so that there was a whole bunch of litigation going on back and forth on behalf of various Black Panthers and over and against the police departments. So what happened on January 17th of 1969 is 3 members of the Black Panther Party in the state of New York, one of whom was Joan Byrd, who was the Secretary-Treasurer of the Black Panther Party in New York, were riding in their car along the Hudson River Parkway. And a police cruiser, New York City police cruiser, pulled up behind them, having, through surveillance, which is revealed through the COINTELPRO revelations, the counterintelligence program of the FBI. There were a whole series of lawsuits against the FBI proving that they were working with police departments engaging in political surveillance against different organizations, not just the Black Panther Party, but the National Organization for Women, the environmental groups, the anti-war groups. This is all a matter of record, that the FBI was coordinating with special groups they called boss squads, bureaus of special service inside the police departments in the major cities. The progressive community used to call them red squads because they considered everybody to be pinkos who were opposed to the war or were advocating black civil rights or feminist rights, et cetera. They were all pinkos. They were all kind of fellow travelers of communists in the Viet Cong. And so that these red squads were surveilling the Panthers, so they had the license numbers of all their cars. And so what happened is this police cruiser was pulled up behind them on the Hudson River Parkway and rammed them in the rear. And the Panthers continued to drive along, and the police cruiser rammed them in the rear again. And then the police cruiser pulled up beside them on the driver's side, pulled up, and the police officer sitting in the passenger seat pulled out his service revolver and turned and pointed it out the window like that right at the driver. At which point, the Black Panther driver reached over and picked up a .357 Magnum off the seat of the front seat of the car and blew away the police officer. Blew him up, actually, with a .357 Magnum all over the other police officer. The other police officer crashed the car. He got into the car and started calling for police backup. Helicopters came in, 20 police cars all surrounded the place. The drivers pulled the car off the road, jumped out of the car, and ran up into the woods off the Hudson River Parkway. Joan Byrd, being 8 months pregnant in the back seat, just cowered down, got down onto the floor behind the front seat, got down on the floor, and when all the police surrounded the place, they came out, found her in the car, dragged her out of there, beat her, took her to the 32nd precinct, interrogated her, and physically abused her, which was proven later, and kept insisting that she reveal who the people were that were in the car, because the car was registered to her, so they didn't have any extrinsic evidence as to who any of the other people were. They arrested her on January 17th of 1969. They held her for 22 days as a material witness. She finally, on February 9th, they arrested 2 other members of the Black Panther Party, a Lumumba Shakur and Clark Squire. And they brought them in for arraignment, and they were represented by the law commune, and all of the charges were dismissed against them in the probable cause hearing because they had no probable cause whatsoever to believe that these guys were the people that were driving the car. So all the charges were dismissed by the court, and Joan Bird was released. Well, the police were furious about this, as you might guess, and within 20 days, on April 2nd of 1969, 200 police officers swept down on all the leadership of the Black Panthers in the state of New York. And they arrested the top 21 leaders of the Black Panther Party, and they incarcerated them on April 12th of 1969. They held them under a total of $2.1 million bail until May 13th of 1971, 23 months later. They held them in captivity. They were kept in the Manhattan House of Correction for men and the women. And the case came to trial on September 8th of 1970, and I was asked by the law commune to assist in that case, filing various motions, and it was a blazer of a trial. Went on for 8 months, from September 8th of 1970 to May 13th, the longest running trial in the history of New York at that time. And Judge John Murtaugh was the chief judge, was the judge at that time. And Murtaugh and the lawyers from the law commune, Fred Cohen, Jerry Lefcourt, Marty Stoller, Bob Bloom, Carol Lefcourt, Sanford Katz, myself, were there struggling with John Murtaugh. Murtaugh, for example, tried to seat on the jury. Well, one of the charges that were made against them, the charges that were made against them were conspiracy to commit murder, to wit, the police officer, but also a bombing conspiracy, allegedly planning to blow up the Statue of Liberty on the 4th of July, planning to blow up the Bronx Botanical Gardens on May 1st, planning to blow up Macy's and Gimbel's on Thanksgiving Day during the Thanksgiving Day parade, and planning to bomb the 42nd Precinct, which just happened to be directly across the Hudson River Parkway, across the Hudson River, a mile plus away, and that the allegations in the complaint were that they were planning to blow up the 42nd Precinct, and when the police officers fled from the precinct after the bombing, they were going to try to assassinate them by picking them off from a sniper's nest next to the Hudson River Parkway, which was over a mile away. And the district attorney, Frank Hogan, kept saying over and over again to the jury, it's not necessary for it to be possible. All that's necessary is that's what they planned to do. And it turns out that the source of all of this information was an undercover informant that had been placed inside the Panthers by the boss squad of the New York City Police Department, who is the one who kept suggesting they do these kind of things. And so that what had happened is because they had the people inside the Panthers trying to instigate them into doing these kind of things, they had a very clear idea of what the kind of things were that the police had in mind, that if they did them, it would be just horrific. And so that they got so freaked out about this incident that had happened, and that the people who they thought had done it had all been, had charges dismissed against them, that they just swept down on them and arrested them all and charged them with having conspired to do exactly what their undercover informant had been trying to persuade them to do. So this thing went on, and Judge Murtaugh actually tried to seat on the jury the father of one of the police officers from the 42nd Precinct, who said that, Judge Murtaugh said, now, I want to make it clear to you, if you're going to sit on this jury, you have to agree that you will be objective about this. And the guy said, oh yes, I'll be objective. And when Jerry left court, tried to challenge him for cause, Judge Murtaugh said, what cause? What cause? He said, he's already said that he can be objective about this. So it went on like this day after day after day after day. But it started with them designating the case as the people of New York versus Joan Bird et al. And all the lawyers en masse protested it being called the people versus Joan Bird. Because he said, this isn't the people versus Joan Bird, it's the state. This is the state versus Joan Bird and the Panther people. So that wrangle went on for 3 days. 2 lawyers were held in contempt. Judge Murtaugh put them in jail that afternoon. He let them out the next day. This went on over and over and over again, every single day. I mean, just a bloodbath in the courtroom. I mean, a huge fight going on in the courtroom. The case went on for 8 months and on 157 separate criminal charges after an 8-month trial. And the defendants were held incarcerated for 23 months. It took the jury 45 minutes to return a verdict of 157 innocent verdicts. And Judge Murtaugh, we were all there at the courtroom, of course, and Judge Murtaugh, people jump up and start celebrating. Judge Murtaugh's banging his gavel like this, and he says, silence, 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 he says. And he says to the jury, he says, there's no such thing as an innocent verdict. All there is either guilty or not guilty. You're to go back into that jury room, and you're to come out with a verdict of either guilty or not guilty. And he sent them back in, and 13 minutes later, they came out with 157 innocent verdicts. Again. And Murtaugh slammed his gavel down, like it bounced off the ground onto the floor, and the jury all jumped up like this and ran all the way across the room and started hugging all the defendants and all the lawyers, jumping up and down and dancing around in the courtroom. And Howard K. Smith came over to me, ABC television guy, and he said, Mr. Sheehan, he says, you people have been complaining all during this trial that the system isn't working. The system is unjust. Now, they've all been acquitted by an American jury. Don't you think that that shows that the system works? That was his question from ABC. I said, well, if you mean by, incarcerating for 23 months, people that it took a jury after 8 months of the prosecution presenting evidence, that it took them 45 minutes to acquit them, and every single one of them were found innocent, then I would say that the system works. And of course, that went out on ABC television, and the law firm said to me, what is it you're doing? This is not a furniture company that you're suing here. And so while we were going and having these discussions, I used to spend more time talking to Larry McKay, who was the chief counsel, than most of the other partners in the law firm. Yes, Randy?
The Defense Authorization Act, will that even get to court today?
Well, the defense authorizations, which we're going to talk about in the course, is those kinds of cases would not. Yeah. No, that's right. Right. Those are allegations of terrorism, and that if in fact a determination were made by the law enforcement officials, in this particular case the president or his designee, and we'll get to this thing. There's a National Defense Authorization Act that I mentioned Tuesday, was signed into law by President Obama at 11:55 p.m. on December 31st of 2011, authorizing the president or his designee to designate a person as a belligerent. That if a person is determined by the president or his designee to have lent any material support to any person who engages in an act of belligerence against the United States, that in fact they're allowed to be arrested without any probable cause shown to any judge, any magistrate, held without right to counsel, held without the right to habeas corpus. That means they cannot in fact demand that they be presented within 48 hours to a federal magistrate to review the evidence that's in hand. For example, what happened with the 2 defendants in the Panther case, the Lumumba Shakur and Clark Squire, the judge dismissed all the charges against them right at the preliminary hearing stage, that there was not probable cause to believe that they were involved in this. And but under the National Defense Authorization Act, if allegations like this were made by the president or his designee, it would never get to a judge. They'd never have the ability to pass on something like that. So we're going to be discussing that particular piece of legislation in the context of the devolution of the judicial system in the country.
I thought even prior to that bill being passed with the Guantanamo Bays being denied their habeas corpus rights, that had already been precedent even before Obama said it.
Except that that didn't apply to Americans being arrested inside the United States. That was one of the major issues that was discussed in that case. These were people that were found to be enemy combatants that were found on the quote, the battlefield. What this statute does, the National Defense Authorization Act, expands, quote, the battlefield to cover the United States territory and to cover American citizens, which it didn't cover before.
I thought that Constitution covers any person because it says people, not
Yeah.
citizens.
No, and that's a reason to be concerned about the federal Supreme Court ruling authorizing some of the stuff with regard to Guantanamo. But the fact of the matter is that when they went on to make it even worse, to apply to American citizens for activities here inside the country, and they have a definition of bellicose conduct, which has to do with attempting to do anything that would coerce large portions of the population to engage in conduct contrary to their will. That's the definition of bellicose activity. And so we'll get to that, but this is an example of what the status was back at that time. The question that Howard K. Smith asked, doesn't this show that the system is working? And that in some sense it was working at that time, better than it's working now. The next case that I did was in September of 1971. Yes, I just want to give one more case, and then we want to chat with some questions. This is the Attica Prison case. This is the Attica Prison Riot case that on September 9th of 1971, while we were in the midst of finalizing our appellate briefs at the United States Supreme Court in the Pappas case, a riot broke out at Attica Prison in Buffalo, New York, the state prison. This had followed the killing of George Jackson on August 21st of 1971 at San Quentin, which has been now proven by papers that were uncovered through discovery against COINTELPRO again, that there was a COINTELPRO government-instigated riot, attempted prison break there at San Quentin, and George Jackson was killed by prison guards during the course of that. And it caused great distress on the part of a lot of prisoners throughout the country. And a number of meetings were being held by the inmates at Attica Prison in Buffalo, New York. And the warden, Mancuso, issued an order prohibiting them from having any meetings about this. And so what they did is the inmates organized a football game out in D Block, in the D yard, and they were having a football game, and they were discussing this case that had happened all during this. And the guards came in and tried to break them up, saying that they weren't authorized to have these meetings. They said, "Look, we're playing a football game," and then one of the guards grabbed one of the inmates, and the inmate punched out the guard. And so the rest of the guards took the position there was a fight going on. The inmates took the position that this was a football thing and he got in the way during a football play. But the bottom line is the guards descended upon them and started billy clubbing them, and the inmates fought back and they took D Block. And the riot broke out on September 9th. I received a telephone call at the Cahill firm from Bill Kunstler. Bill Kunstler called me because of the previous work I'd helped do over at the Law Commune, and that I had been appointed by Mayor John Lindsay, the Republican mayor of New York at the time, to be the lawyer for all of the inmates in the Manhattan House of Correction in New York City. Another one of the pro bono jobs that I was doing, because my father had been a prison guard in Great Meadows Prison in Comstock, New York. So I knew all about these kind of things, and I knew about inmates' councils and other things. And so I'd been appointed by Mayor Lindsay to be the lawyer for all the inmates in the Manhattan House of Correction. And so Bill Kunstler contacted me and asked me to fly to Buffalo right away to go in to argue a case in front of Judge Curtin, John Thomas Curtin. Everybody calls him Tom Curtin. I went in, I got ready to fly in, so I had to go see Floyd Abrams. Floyd Abrams was my senior partner, and so I had to go touch base with him because I was in the middle of briefing the United States Supreme Court about this right of journalists to protect their confidential news privileges. So I had to go up to find Floyd to get permission to leave for a couple days to go argue this case up in Buffalo. And I went to find him and he wasn't there. I found Gene Scheinman, who was his number two, who was Scheinman and Sheehan. We were the Jewish and Irish associates that they were going to track together. So Gene Scheinman and I went to see Scheinman and I told him that I'd been asked by Kunstler to come fly up, and so I asked him to tell Floyd about this. So I go out and I go back to my office and I pack up some stuff to do, and I go out and I push the button on the elevator and the elevator door opens up and there's Gene Scheinman with his bag all packed, getting ready to go with me. So we go to the airport, we fly up to Buffalo, we get picked up at the plane, and they bring us to University of Buffalo, and there's Kunstler and some dozen other lawyers that are all there. I go in the next morning on the 10th, Friday the 10th, and I argue in front of Judge Curtin, demanding that he sign a federal court order commanding Warden Mancuso not to engage in any retaliation against the inmates who have been involved in this thing. And so he signs the order. They bring the order out to the court. I asked him to order lawyers into the prison because we were afraid that the New York State Police were going to attack the prison and try to kill all the inmates that were involved in the riot. And so we asked Judge Curtin to sign an additional order ordering us into the prison. He took it under advisement on Friday afternoon on the 10th of September. We got word on Sunday evening on the 11th or the 12th. We got, no, it was Sunday evening on the 11th. We received word about 7:30 that the police were mobilizing to move on the prison. So we called Judge Curtin and went out to his home, actually, on the evening of Sunday, September 11th, went to his home with him in his bathrobe in the kitchen, myself, Gene Scheinman, and Herman Schwartz. Herman Schwartz, who was the chief counsel for the American Civil Liberties Union for the Western District of New York, and went on to become chief counsel for the United States Senate Judiciary Committee later. But he was there with us. We were in the kitchen arguing to get the judge to agree to let us do this when the police hit the prison. The police hit the prison. Turns out that there's some 200 police officers surrounded the prison, and then they were reinforced with 400 more. They surrounded the prison, and they hit the prison. They flew a helicopter over the D yard and dropped tear gas into the yard, and then the police on the parapets all fired down into the yard. The evidence we were able to establish that 2,000 rounds were fired from the parapets by the police down into the yard, killing all 29 of the prisoners who were there in the yard and all 10 hostages. Judge Curtin immediately signed an order authorizing 3 of us to go into the prison and to bring with us 20 doctors. So we gathered up the doctors and we got into these. We got 2 big Volkswagen vans and then a few cars of all the doctors in them. We go out with the federal court order out onto the New York State Thruway. It was all completely shut down, the Thruway, from Buffalo all the way out to Attica Prison. And they had big National Guard mobilized. They had big military trucks going everywhere with full armed National Guard people. We showed the court order to the commander at the Thruway entrance. They let us onto the highway. We were driving out in our cars, the 2 Volkswagen buses and the 4 carloads of doctors. And we were driving along the highway, and about 10 New York State patrol cars, troopers, came rolling up with their red lights and sirens going and started pushing us off the road. And they pushed us off the road to the side of the road, and it was now by this time it was dark time, and it was raining. This kind of mist, this strange gray mist was everywhere. And they pushed us off the side of the road, and they were all wearing these big phosphorescent orange slickers. these rain slickers, and they had these big riot masks on, you know, with the big, I guess you don't know, but we got used to it back in the 60s, but they had these big plastic visors on their face and these great big gigantic clubs that they used to carry, and then shotguns with double buckshot in them. And so they pushed us off the road, and Herman Schwartz had gotten Judge Curtin to put into our court order a provision which made it a federal crime for anybody to interfere with us traveling on the highways. It was an old adage that was done by the civil rights workers down in the South to protect them against Ku Klux Klan people interfering with them on the highway. So he put the provision in. So they've got us pulled off the road, and here's all of these. There must have been probably 30, 40 state police all around us, and they had these tire gauges, and they were actually down on their knees measuring the depth of the treads on the tires of our cars. They were trying to figure out any conceivable thing they could come up with to keep us from being allowed to go to the prison, right? And so I come over to them, and I hold a copy of the federal court order, and it's raining kind of on us. And I remember looking at it with the mist and the rain on the court order. They had a flashlight on the tires, putting the tire gauges in. I held the thing down in front of this guy, and I said, "You see that paragraph right there?" I said, "I want you to read that paragraph." And he said, "I'm not going to read the paragraph." I said, "I'll read it to you." I said, so I read in the paragraph, making it a federal crime to interfere with us on the highway. And I said, "And that means you." I said, "And so I want to know where your barracks commander is." And it was the strangest thing, because I hadn't thought about that for 20 years. But because my dad was a prison guard, we used to know all the New York State Police back in New York, and we knew that there was a barracks commander that was in charge of the group of these guys. And so as soon as they heard that word, as soon as they heard me say, "I want to talk to your barracks commander," I mean, everybody just froze. It was like this absurd scene where just everybody froze solid like that. Everybody you could see. And they all turned like that. And the guy got up like that, and he said, "That's him over there." So I walked over to the guy, and I said, "You're the barracks commander?" He said, "Yes." I said, "Here's the federal court order signed by Judge Curtin. You are interfering with us on the highways. This is a federal crime." I said, "I'm going to let it go right now, but you've got like 5 minutes to move everybody out of here, or I'm going to insist upon you being prosecuted for this. So you got some time here, so you just mobilize your guys and get them out of here." And he looked at me like that, and just as he was looking at the thing, trying to read the thing, he and I looked up, and over at the second van, where Gene Scheinman was in the van, there was this great big gigantic state police officer in this big orange slicker, and he was scowling down into the window of the car like that. And I went, "Whoa." I said, I grabbed the barracks commander. I said, "Let's get over there." So we went over to the window like this, and I said, classic, I said, "Hello, officer, what seems to be the problem here?" You know, right? That's the opposite of "Show me your barracks commander." You know, that's "Hello, officer, what seems to be the problem here?" And he turned and he looked at me. And what had happened is he'd come up to the car with the shotgun, and and Gene had rolled the window down, and the police officer had said, "You don't mind if we take a little look in here, do you?" And he grabbed the back of the door of the Volkswagen bus and pulled the door and started to slide it open like that. And Gene had initially said, "Why, no, of course." And so he went for the door, and then Gene got his wits about him. He says, "That is if you have a warrant." And the guy backed up like this, let go of the door, and he loomed over and he said, "So it's going to be like that, is it?" That's what he'd said. "It's going to be like that, is it?" And that was when we'd seen him, you know. And so I bring the barracks commander over, and he shows them the court order, and they mount up and they pull out, right? So they all pull out. We go back and get in the cars, and we get back up on the highway, and we're driving out to the prison, right? And it's nighttime, and the rain is coming down, and it's all misty and weird, and we're on the highway, and then one of the police cars comes tearing out behind us and rams into the side of one of the Volkswagen vans all by itself. And the other police cars come up and push him off the road to get him to stop doing that, right? So then we go on into the prison. We go on off the exit over to the prison. We come to the prison. It's like this weird mist. There are big spotlights up everywhere, and there's this mist. So all the light is reflecting off all the droplets there in the nighttime. And the helicopter that had dropped the tear gas in is laying on its side. It had crashed and it was laying on its side with all the propellers broken like that, and this tear gas was just everywhere. You could smell it. And so we go driving in, and I've got the federal court order, right? So I go walking through these guys, and I said, it's federal court order, and we're walking through, and here's all these guys with shotguns, growling, snarling. I mean, there are people dead everywhere. You know, I mean, there's 41 people laying there dead everywhere, right? So we go in, and I go up to the door of the prison, and there's these two great big gigantic state police officers there in these phosphorescent rain jackets, right? I said, it's a federal court order. We're serving a federal court order. I go up to the door, and I knock the door like this, and this little slot opens up, and I had a signed copy of it, a certified copy, and I pushed it in, and I said, this is a federal court order from Judge Curtin. I said, that's the same fellow that signed the court order that was delivered here earlier about no harassment to these people. I said, and this is a federal court order ordering us into the prison. I said, and this is a court order, and you'll be in contempt if you don't obey this. And so they go click, and they close the door like that. So I'm standing there waiting, and these guys are just glowering at me, right? These two great big guys, right? And so I'm just sitting there waiting, and then they slat the door open, and they say, they push it back out, and they say, court order or no court order, you ain't coming in here. We got a state of emergency in here, and no one's coming in. And he slams the little door closed like that. And the great big cop looked at me, he says, you heard him, asshole, he says, and he goes, blam, like that, and he hits me with the butt of the shotgun. I mean, right over the shoulder, like just whacked me just like that, right in the side of my neck, kind of knocked me down. And so I was just, you know, I didn't want to get too carried away with this. And so I jumped back up, and I said, okay, you're in federal contempt of court. I said, you'll go to prison. I said, you'll lose your entire salary. Your kids won't go to college. I said, I want to make it real clear what's getting ready to happen to you if you don't back off on this thing. And he just looked at me like that, and he kind of took a step back like that, and I said, and I ain't leaving. I said, nobody comes in or goes out of that prison. I said, we're going to inspect every one of those bodies before they go anywhere. And then Herman Schwartz and Gene Scheimer are standing at the bottom of the stairs going, oh, gee, like this. So I said, Herman, come here. So Herman comes up on the stairs. I say, Herman, I said, I want you to go right now and call Judge Curtin. And I want you to have Judge Curtin enter an order nationalizing the National Guard. And you have them arm themselves and take this prison back from these state police. And Herman looked at me like that, and he said, my God, Danny. And I said, it was a terrible line, and I'm embarrassed about it. But I said, Herman, you're in the big time now. That's what I said to him. So Herman went, okay, I'll do it, he said. And he turns around, he goes down off the stairs, and he goes looking all over the prison. Nobody would let him use the phone. They didn't have any cell phones. They wouldn't let him use any phone. Fuck you. They're saying, you aren't going to get a phone. So he goes back and gets in the car. He has to drive all the way back off the thruway to go back into Buffalo to get a phone, right? And about an hour later, I'm just sitting here. I'm sitting here in the rain on this thing, rain falling down on me like that, and these guys glowering at me, and Gene's sitting there kind of hoping I don't get killed. And so the Herman Schwartz comes back, and he says, Judge Curtin says that that's a little much. He said, but what he will do is he's scheduled an 8 a.m. hearing, and Mancuso is ordered to be there. He said, or else he'll be held in contempt to make an accounting for everything, and you're allowed to stay here to inspect these bodies. And so I go to the door, and I knock the door, and they open it up, and I tell them this, right? That Mancuso has to be at this hearing at 8 o'clock, and that we have a right to inspect all these bodies. So we're there, and it's starting to get daylight, and out comes Mancuso with two of the prison officials, but this time, all of a sudden, news media starts showing up. Like about 20 cameras and microphones and all this stuff. They all come rolling up like this, and out comes Mancuso and announces that all 29 inmates and all 10 hostages have been killed by having their throats cut by the inmates, right? And he's got an official coroner, New York State coroner's report on each one of the 39 bodies. Okay, and so I said to Herman, I said, look I said, you go find the county coroner. I want you to go find the county coroner right now, and get him here, right? So he goes and finds the county coroner, and the county coroner comes, this guy Dr. John Edlund, and he comes there, and so I said to them, we've got the county coroner here. I go to the door and I tell him, and he's coming in and he's going to inspect these bodies. And they're just terrified. They're just terrified. And I say, Doc, you stay right here. You're not going anywhere until you go in there and inspect those bodies. And like about 20 minutes later, out comes Mancuso back in front of the lights. He says, oops, sorry, that was just a mistake. It was like an error. It turns out that all of them had been killed by double-aught buckshot. All 29 prisoners and the 10 hostages. So we succeeded in getting the reversal of that, and that led to major damages, lawsuits that went down against the state of New York, which they've become part of history with Rockefeller and later on the other governor of New York. So those were the cases that I started doing when I first arrived at the Cahill firm. Thank you very much. Happy Passover and happy Easter.